Hi, I'm Bernice. I'm a 1L here and also a global law scholar. And I am excited to welcome you guys to the day 3 of the 10th International Arbitration Month here at Georgetown. Thank you so much for coming out on a Friday afternoon. We really appreciate that. We're going to start today with the first panel, which is enforcement of interim awards and emergency awards. We're going to have Patricia Rios-Ruz, the Secretary of GIAS, moderating this panel. And we have 3 wonderful speakers here, which I am really excited to introduce. We're going to start off with Anna Marie Whitesell, who's a professor and LLM program and faculty director of the Program of International Arbitration and Dispute Resolution of Georgetown, here at Georgetown. Ms. Whitesell has practiced with law firms in both the United States and in France, and has acted as arbitrator and counsel in numerous international arbitration cases. She was the Secretary General of the ICC, International Court of Arbitration, from 2001 to 2007. She also previously taught at the Université de Paris and the Institut des Droits Comparés. She serves as a member of various boards and committees related to dispute resolution and is the director of the Alternative Dispute Resolution Center of the International Law Institute. Ms. Whitesell received her AB from Smith College and her JD from the University of Virginia School of Law and her doctorate in law from the Université de Paris. Pardon, Sabon. I'm pretty sure I pronounced that wrong. She's admitted to the New York State Bar and the District of Columbia Bar and the U.S. District Courts for the Southern and Eastern Districts, and the Southern and Eastern Districts of New York. Moving on to the next speaker, it's Hugh Carlson. He's the managing director of 3 Crowns, in which capacity he's responsible for the firm's global operations. He also serves as a general counsel to the firm. Hugh has represented clients across a range of industries and under most major arbitral rules systems. He has been described in Who's Legal as absolutely phenomenal and commanding the respect of his peers and highly recommended for his international investment treaty and commercial arbitration work. Hugh teaches international arbitration at Harvard Law School and Georgetown Law. Prior to joining 3 Crowns, Hugh practiced in the litigation and international arbitration group of a major international law firm. He received his legal education at Georgetown Law and the Queen's Mary School of International Arbitration. His introduction to international arbitration many moons ago was in Mark Kantor's course, International Business Transaction. And that is a great segue to the next speaker, who is Matt Kantor. Professor Kantor currently serves as an arbitrator and mediator. He teaches as an adjunct professor here at Georgetown and was the recipient of the FA Award for Outstanding Adjunct Professor. Mr. Kantor serves as a member of the World Bank Group Sanctions Board until 2021. He was formerly a member of the Board of Directors and then the Council of American Arbitration Association, former chair and vice chair of the DC Bar International Dispute Resolution and International Investment Committees, and a chartered arbitrator of the Chartered Institutes of Arbitrators. Mr. Kantor is also a member of the editorial board of Global Arbitration Review, the board of editors the board of editors of the Journal of Damages in International Arbitration, the editorial board of the Journal of Technology in International Arbitration, and the editorial board of arbitration. The International Journal of Arbitration, Mediation, and Dispute Management, and the ADR Advisory Board of the International Law Institute. Quite a list of accomplishments for all 3 of our speakers, and we're excited to hear them speak and talk a little bit more about themselves for about the first hour of our panel, and then we will open it up to Q&A sessions. Thank you.
Okay, well, good afternoon, everyone. I will take off my mask so that the panelists and the audience can hear me better. We are thrilled to have you here in person and have these distinguished practitioners with us today to discuss the enforcement of interim awards and emergency awards. Before starting off, I think it's crucial to ask ourselves, why is this topic so important? So, the arbitral award is one of the most important documents in the world today, because no court can review it on its merits, and it is enforceable almost anywhere in the world because of the New York Convention. However, because of its power, or despite of it, the New York Convention doesn't define what an arbitral award is. And that translates into the same trend in most national arbitration laws. They leave this concept undefined. Additionally, there are some inconsistencies in the international arbitration rules of some arbitration institutions. For example, Article 2 of the ICC Arbitration Rules 2020 say that the award can be interim, final, additional, or partial, which means that arbitral tribunals can render more than one type of award. When it comes to interim relief, the arbitral tribunal can render their decisions in the form of orders or awards. At the same time, when it comes to emergency relief, some courts around the world have said that this type of decisions are orders, while others have arrived to the opposite conclusion, saying that they are awards. So as you can see, there is not that much consensus in the international context. So to start off, and to get some background, because there may be not so many students familiar with the topic, we will start off with a very general question, that is, what is an interim award and what is an emergency award? Professor Whitesell, would you like to answer this question?
Thank you, Patricia. Can everyone hear? Because we are trying to decide whether we keep our masks on or not. But if you can hear, then we will keep the masks on. Before I answer to your question, Patricia, I want to start by congratulating GIAS for this event. I know how hard you have been working this year, and I am personally very proud of the work that GIS has been doing on behalf of the law school. So thank you again. And I want to also thank my co-panelists, because it's such a pleasure to have them here at the law school. Both of them are very familiar with the law school and spending much time at the law school. But for us to be together today is quite a privilege and a pleasure. So now, turning to the specific question that Patricia has asked me about what is an emergency award, what is an interim award. Starting this panel, where that's what we're going to be discussing, it is very important for us to clarify the terminology, because we're using these terms today to refer to decisions which are used to grant interim measures, whether they're in the form of an award or in a different form. And so what I'm going to do is cite to the UNCITRAL Model Law, which tells us that an interim measure is any temporary measure issued prior to the final award deciding the dispute, by which the parties are ordered to, and then UNCITRAL gives us these examples, maintain or restore the status quo pending determination of the dispute, take action that would prevent or refrain from taking action that is likely to cause current or imminent harm or prejudice to the arbitral process itself, provide a means of preserving assets out of which a subsequent award may be satisfied, or preserve evidence that may be relevant and material to the resolution of the dispute. So that comes from the UNCITRAL Model Law itself. Now, the intent of these decisions is to grant urgent conservatory relief, which is aimed at preserving the status quo to protect the rights that are actually the subject of the dispute. And so these measures are given different names. In addition to interim, you will hear them referred to as provisional. You'll hear them called conservatory. You'll hear them referred to as protective. But the decisions that grant these measures are also sometimes referred to as awards, as Patricia told us, sometimes they're orders. And this terminology, it may make a difference based upon the rules that are applicable to the arbitration proceeding, and also based upon the courts that may be required to view the decision that is rendered. So terminology does matter in this area of law. Now, an interim award or order is a decision that's given by the arbitral tribunal that has been appointed to decide the dispute, which is granting the interim relief. And the power of arbitrators to grant this type of relief is now very widely recognized. But we still need to remember, and I can see some of my students in the audience, as you know, that there are certain jurisdictions where this is not allowed. This continues to be the case in China, in Italy, it's under review. But you need to make sure, again, about the situation in each jurisdiction. And the purpose of these decisions is to allow provisional measures to be granted within the framework of the arbitration. So not requiring you to go to court, since what the parties have done is chosen arbitration as an alternative to the courts. Moving to an emergency award or order. This is a decision that's given by someone who is appointed before there is an arbitral tribunal. So because there's an urgent situation, we don't even have enough time to wait until the arbitral tribunal is in place. Most of the institutional rules have provisions concerning emergency arbitrators, and similar to what I've just said about interim decisions given by arbitral tribunals, again, the idea is to allow the parties to get interim conservatory relief without having to go to court, recognizing it may take some time to get the arbitral tribunal in place, and because these are urgent decisions, we need someone else to be able to render that type of decision. So again, considering terminology, whether the person rendering such an emergency decision is truly an arbitrator is something that should be discussed, because we call these people emergency arbitrators. They have been appointed before the arbitral tribunal. I am not sure, again, that these people are truly arbitrators. So that's something maybe we will be able to discuss during our panel. So with that basic introduction, I turn it back to you guys.
Thank you. Thank you very much, Professor Whitesell. Would any of the other panelists, Mark or you, would like to add anything?
Patricia and Anne-Marie, I would only add one more point. There are times when an interim award is not addressed to interim measures, but can instead be addressed to a merits issue in the arbitration, but intended to try to resolve one particular aspect of that dispute without seeking to resolve other aspects of the dispute.
Well, thank you very much.
And Mark, I would add, as you said, there are many interim awards that do not concern interim measures. And there are interim awards that by their name, they are enforceable in some jurisdictions, but not in all jurisdictions. So terminology matters an enormous amount in this area.
Well, thank you very much to both. I think that we can go on to the next question. What are some ways to compel the parties to comply with the award or decisions of the emergency arbitrator? Hugh, would you like to answer this question?
I'd be happy to, but before I do, allow me to echo Anne-Marie in expressing my gratitude to GIAS for the kind invitation to present along two distinguished co-panelists. It's a pleasure to be back on campus. So before we arrive to the question of how to compel a party to comply with an emergency arbitration award or order, it's perhaps useful for us to take a step back and think a little bit about what that means in order to secure one. As many of you will know, emergency arbitration decisions and awards have much in common with their final arbitration award siblings. And Marie, I think, quite hopefully just touched on some of this. But just to add to that, they cannot be obtained ex parte. They will not bind third parties. And if award debtor does not voluntarily pay, some form of judicial enforcement may be required. In the context of emergency arbitration, the ex parte point is perhaps worth emphasizing. Emergency arbitration is not infrequently considered in the context, as Anne-Marie touched on, of protecting the status quo, which can entail concretely preserving a counterparty's assets from being hastily transferred to a safe jurisdiction. And so if you are considering the prospect of emergency arbitration and would need to communicate to the counterparty that you are going to be bringing this forward or that you have brought it forward, that may result in the transference of those assets, which means that there may be a threshold question as to whether you pursue emergency arbitration or you instead opt to pursue this in the courts. Now, there are some significant upsides to emergency arbitration that shouldn't be lost upon us. One is that it provides single forum relief. That means that it's excellently suited for disputes that cut across multiple jurisdictions, like in intellectual property. Another is confidentiality, with which many of you will be familiar already in the arbitration context. And third, as Anne-Marie touched upon, speed. Concretely, emergency arbitration tends to take about 2 weeks, depending on the specific rules in place. Now, when you're considering the ex parte aspect of this, just because the courts are available doesn't necessarily mean that they'll be the best path forward. There could be difficulties, for example, in bringing an action in the courts if emergency arbitration is already available to the parties. An example of where this is the case is pursuant to the English Arbitration Act of 1996, which introduces some difficulties potentially to parties who are looking to the courts for recourse to serve in the role that an emergency arbitrator would otherwise if it's available to the parties. So that kind of sets the stage for the question, which is a good one, which is how do we compel parties to comply, assuming that we've gone the emergency arbitration route? And here it pays to do due diligence as an attorney as ever. So if you have familiarized yourself with where the counterparty has assets located, that can inform the decision as to whether you are going to be pursuing emergency arbitration in a given jurisdiction and how you will go about enforcing it in a separate jurisdiction. Similarly, if you are thinking about how to compel the party to cooperate with the emergency award, you'll also recall that you may have as arrows within your quiver ones similar to those that come across in the interim measure context. That is, that you might seek an award of costs at a later stage, a point that you can make evident to a counterparty in a letter. Similarly, it can come up in the context of adverse inferences, although perhaps a little bit less applicable in the emergency arbitration award context as opposed to the interim award context. But the broader point, and the one that I would really emphasize here, is that speed will potentially be of the essence. And so having done your due diligence, once you have that piece of paper, once you have the emergency arbitrator award or order, being able to hastily submit that in the jurisdiction in which you're seeking enforcement is perhaps going to be the most effective way to encourage or compel compliance with that document.
Well, thank you very much. Professor Whitesell or Mark, would you like to add anything?
I would only add that one of the most common tools for persuading a recalcitrant party to comply with an order of an arbitrator is not present in the case of an emergency arbitrator. And that is the risk that the recalcitrant party will irritate the arbitrator. The emergency arbitrator generally plays no further role in the arbitration after he or she has issued an emergency award. So a recalcitrant party really doesn't mind too much irritating that arbitrator. That arbitrator doesn't play a role. So no matter how balefully I look at a party when I issue a decision as an emergency arbitrator, it probably has no impact.
May I just, to respond to that, Mark, as an advocate, if the recalcitrant party didn't play ball with the emergency arbitration award and we find ourselves subsequently in arbitration, I would raise that though, from what you're saying, it sounds like you wouldn't be particularly compelled by that. Is that right?
If I were sitting on the permanent tribunal, the full tribunal, rather than acting as emergency arbitrator, I would certainly listen carefully to that because it might tell me a bit about whether I'm going to have a problem with this party in my arbitration. But I'm fairly confident that the recalcitrant party will come up with their arguments for why they didn't comply with it. And I'm not going to decide that question unless compelled to do so by a request for sanctions, which would either be costs or, as you point out, less likely an adverse inference. So as the member of the permanent tribunal, I might tuck that away and think about how that affects how I view a party. But I wouldn't regard it with the same personal level of irritation as I would if it's my own award being disregarded.
And I would add that if we look at the institutional rules that have these emergency arbitrator provisions, many of them have an undertaking. The parties will comply with the decision of the emergency arbitrator. So there you could raise this argument that becomes part of the party's contractual obligation. And by not complying with that emergency arbitrator decision, you're not satisfying your contractual requirements. I think one other way that we could also try to push for compliance is under certain laws, both emergency arbitrators and normal arbitral tribunals are allowed to include penalties in their decision. That's not everywhere, but so that if you're not complying with the decision, then there will be penalties being applied. And so that definitely may push someone to be more willing to comply.
It's an excellent point, especially because I think, as you say, in certain jurisdictions, that may not be accessible. You could probably speak to the civil law context here. I think that contempt of court doesn't really exist in the same way as it does in the common law. So hardwiring it into the emergency arbitration can be very useful.
So France is an example where it's recognized that arbitrators can include penalties in these types of decisions.
Okay, well, thank you very much. As you can see, there are a lot of issues around emergency arbitrators and also interim awards. Your responses also go forward to the next question that we have. Does the appointment of an emergency arbitrator preclude a party from seeking the assistance of the relevant national courts? This question goes for Mark.
Thank you, Patricia. And let me echo my colleagues on the panel by thanking GIAS for organizing this panel and indeed this entire month. I'm hope that it proves to be valuable to the audience, to the students, and I'm grateful for the opportunity to speak. I'd also like to thank Bernice for that very flattering introduction, which I wrote. I've been asked to ask about whether the appointment of an emergency arbitrator precludes a party from seeking the assistance of the relevant national courts. And like so many legal questions, the answer is it depends. There are several levels of legal authority that we have to go through in order to try to answer that question. And we have to go through those levels of legal authority for every relevant jurisdiction. There is first, if we're dealing with commercial arbitration, is there anything in the arbitration clause that speaks to this question? Do we have party autonomy on the point? Second, is there anything in the relevant arbitration rules that speak to the point? Again, a question of party autonomy. Third, is there anything in the relevant national arbitration law that speaks to the question? And might that be permissive or mandatory? Could it in fact override whatever party autonomy might have been exercised in the arbitration clause or the arbitration rules? And then finally, we might come to an applicable international treaty for commercial arbitration. The New York Convention, most obviously, also the Inter-American Convention or the European Convention on International Arbitration being particular examples of that. The arbitration clause in a contract is occasionally poorly written. And I say that being a former transactional lawyer and having committed my own instances of malpractice in trying to write those clauses before I knew anything about arbitration. There are times, including cases that have ended up before the U.S. Supreme Court, where the arbitration clause is sufficiently garbled that a question that ultimately arises in front of the court was whether that clause precluded any access to the courts or precluded any access to arbitration. And the last time a U.S. court had to look at this that I considered, the court concluded that the clause precluded access to arbitration, even though an arbitration practitioner would have probably read it as merely authorizing but not requiring the disputing parties to go to court if they needed assistance of the court for something like interim or provisional measures. The court, not having the benefit of having spent years in arbitration practice or even years in arbitration classes at Georgetown, came to a conclusion that I thought was completely wrong on interpreting that clause. Arbitration rules. Here, let me distinguish between the world of commercial arbitration and investor-state arbitration. We'll talk about investor-state arbitration later. Most commercial arbitration rules authorize both emergency arbitration and access to the national courts for provisional or interim measures on a non-exclusive basis. If those rules are written in the modern sense, and most of them are nowadays, they will not preclude a party from seeking the assistance of the relevant national court. Arbitration laws. Well, if you live and work in the United States, there is no good answer to that from the law itself because the law was written in 1925 and had absolutely no notion of emergency arbitration, nor did it have any notion of choosing between arbitration and the courts for interim measures. More modern arbitration laws, well, Anne-Marie mentioned the UNCITRAL Model Law, again, are often written in a fashion to make clear that the choice is non-exclusive, and that helps. But if you're dealing with a jurisdiction like the United States, you end up with the courts trying to interpret an out-of-date statute. And I will tell you, here in the United States, we have a split in the jurisdictions. And depending on what part of the United States you're in, the answer to the question that Patricia posed to me might be yes, and it might be no. And that's not a very comforting answer to you in the audience, but it's a real-world answer. And it goes right back to the point that Hugh made about understanding what jurisdiction you are seated in and what jurisdiction you might wish to enforce in.
Okay, well, thank you very much. Will Anne-Marie or Hugh like to add anything? No? Okay, well, we can go on to the next question that is also very important and a bit general. This question goes for Professor Whitesell. Should the New York Convention be applicable to interim awards and emergency awards? Why or why not?
So, Patricia, your question is whether the New York Convention should apply to interim and emergency awards, and that is a different question than whether it does apply. As you probably know, this is a question of much debate. The issue is whether the New York Convention, which is for the recognition and enforcement of foreign arbitral awards, and here I repeat that word awards, can apply to a decision which by its nature is temporary and subject to modification, suspension, or being rescinded. Now, some courts have held that the New York Convention can only apply to awards that are final and binding on the parties. Other courts, like the French courts again, they have said that when interim measures are granted, it is an award that becomes immediately subject to being set aside and enforceable. So they've taken that approach. Other courts have said that an interim decision is final as to what it decides. That's an approach here in the United States. So it is a final decision on what it is deciding, even if it's not the final decision in the dispute. And so therefore they will give it New York Convention recognition. So it depends on the definition that we're going to give to awards. And as you started out by telling us, we don't find a definition of award either in international conventions or in most national arbitration laws. But still, generally, there is a requirement of finality. Now, recognizing these difficulties, there have been, I'd say, practical solutions that have been found, particularly by UNCITRAL, again. Today's my UNCITRAL day, and in many national arbitration laws, such as Hong Kong, for example, where there is express provision in the law for the enforcement of interim measures. So we have statutory provisions that specifically say interim measures can be enforced. Another approach has been jurisdictions where there aren't statutes, but where there's been judicial decisions that say, since arbitrators have these powers, we need to find some way to give them effect. So basically what we are seeing is that most jurisdictions have found different methods for giving effect to interim measures, whether they're applying the New York Convention, they're using statutory provisions, or they're doing it through judicial decisions. But back to your question, should the New York Convention be applicable? We have seen an important increase in the number of cases which are involving interim relief, both from arbitral tribunals and from emergency arbitrators. So clearly the availability of interim relief has become an important feature of international arbitration. And so we need to find a way to make such relief effective. I personally think the UNCITRAL approach is the cleanest way to go forward by having express provisions that say interim measures can be enforced. But enforcement is also possible without contravening the New York Convention. So it truly depends upon the preferences of each jurisdiction. But what we clearly have seen is that jurisdictions that want to promote themselves as being arbitration friendly, they have found ways, they have made provisions to make it clear that interim measures can be enforced.
Thank you, Professor Whitesell. Does Mark or Hugh would like to add anything? Okay, thank you so much for that. I think that we can go on to our next main issue. This question goes to Hugh. What are the legal bases to identify the competent courts of justice to enforce interim awards or decisions? And does the UNCITRAL Model Law indicate anything in this regard?
So just before I answer, or attempt to answer this, quick question for the audience. Who here is a first-year law student? One, two, got a couple? Okay. Just very briefly, in case you're unfamiliar, the UNCITRAL Model Law is effectively a template of what a country's arbitration law can involve. And so it sets out the different types of procedures that may be taken into account that may come up in the course of an arbitration. We've already heard a little bit about emergency arbitration. Interim measures is another example of this, but it extends to other aspects with which you will be familiar, for example, recognition and enforcement. So the question as to whether or not the UNCITRAL Model Law indicates anything in the context of enforcing interim awards is that, yes, the 2006 amendments to the UNCITRAL Model Law do speak to their enforceability. Article 17H1 addresses this expressly, and it says that in an interim measure issued by an arbitral tribunal shall be recognized as binding and, unless otherwise provided, enforced upon the application to a competent court. It goes on to say that the court can order the requesting party to provide appropriate security if that hasn't already been determined by the issuing tribunal. But that doesn't end the inquiry. So one question that you may have in mind is how many states have adopted the 2006 amendments to the UNCITRAL Model Law. And the answer is somewhere less than 50. I don't know specifically because while we know who has adopted it, we don't, or at least I haven't done the research as to who has made any changes to the provision in Article 17H. But of the 118 jurisdictions that are considered to be model law countries, a little bit less than half have this. And so just because the model law provides for this, in other words, doesn't necessarily mean that we may assume as advocates that this would be in effect. And this goes back to Mark's very good point in response to the first question that he answered about the different rules and laws that will apply. And as budding practitioners, many of you will find yourselves on the receiving end of requests for research into these different questions, and it'll be incumbent upon you to not just assume, for example, that because the model law provides for X, X indeed applies, but you're going to have to dig in and get into the specifics. So of the less than 50 states that have introduced the 2006 amendments, that sort of ends the inquiry. However, where a state hasn't introduced that, that doesn't necessarily mean that there isn't going to be some provision for the recognition and enforcement of an interim award. And here, the courts can also provide useful insight. For example, we have in the United States jurisprudence that speaks to this, and Mark has already sort of touched on that in the emergency arbitration context, and so too in the UK. But it also cuts in the other direction. In Chile, for example, in 2010, the Chilean Supreme Court rejected that an arbitral award, an interim award could be enforced. And this was on the basis that Anne-Marie touched upon, that it was not final and binding, which are the provisions set out under the New York Convention. And so sometimes it'll be important to take a deeper dive into what courts have had to say on the subject. There is, I think, generally speaking, a trend in the direction of various jurisdictions, common and civil law, looking to treat interim awards or interim orders and decisions as final and subject to enforcement under their laws, but that is by no means the prevailing rule. And so you'll want to take that with a grain of salt, and when faced with a question, make sure that you're undertaking the appropriate research to arrive to your conclusion.
Well, thank you very much. I think that we can go on to the next question. Mark, could you give us your perspective from your professional experience as an arbitrator? Can arbitral tribunals grant interim relief even when their jurisdiction is being contested?
It is not uncommon for an arbitral tribunal to grant interim relief even though a party is disputing arbitral jurisdiction. And the reason for that is it can take a while to resolve whether or not arbitral jurisdiction exists. And if the request for interim measures is an effort to preserve the status quo, to avoid moving of assets, as Hugh mentioned earlier, or to avoid an irrevocable act that fundamentally transforms the prospects for the arbitration, then arbitral tribunal might be inclined to move forward and seek to freeze the status quo. But it's also common for an arbitral tribunal in that context to seek to make a prima facie, depending on how one properly pronounces the phrase, decision about jurisdiction as part of the interim measures decision, to assert that the jurisdiction exists. If it then becomes necessary for that decision to be enforced in a national court, one can easily predict that the question of arbitral jurisdiction will arise before that national court as well. It's a question of whether or not the interim measure ought properly to be enforced.
Thank you very much. That is very interesting. And now we can go on to another topic. Professor Whitesell, you co-authored a book titled Interim and Emergency Relief in International Arbitration. In what circumstances is it advisable to go to the national courts to request an interim or emergency relief, as opposed to requesting it from an emergency arbitrator or arbitral tribunal?
So, Patricia, as your question implies, we all recognize that the granting of interim relief is an area where, except in a limited number of jurisdictions, there is concurrent jurisdiction between arbitrators and national courts. So it becomes a strategy question, actually, for the parties as to whether it makes more sense to go to a national court or ask the arbitrators for such relief. So honestly, the answer to that question will depend on the circumstances of each case. Now, it may make more sense to go to a national court if there are third parties involved over whom the arbitral tribunal does not have jurisdiction. It may also make sense if there's a likelihood of non-respect by the opposing side of the arbitrator's decision, and it'll be necessary to go to a national court for enforcement anyway. Also, there are situations where there's truly urgency. For example, where assets are being removed or destroyed, and it may be better to go to court right away without taking the risk of worrying about the enforceability of an arbitral decision. And there may be issues about requiring interim relief in jurisdictions other than at the place of arbitration, and how enforceable the arbitrator's decision will be in those other jurisdictions, even though UNCITRAL now says that it can be enforced in any jurisdiction. But in many cases, the parties have chosen arbitration to stay out of the courts. They may want the confidentiality of the procedure to be respected, and that may be lost, of course, if they go into a national court. There may be issues of language. If you're in a national court, you may have to translate everything, and questions of national law that aren't relevant if they stay in arbitration. They may prefer to have the arbitrators who know their case, who understand the impact of this interim decision, be the ones that are deciding the issue. And sometimes parties will actually make a request for urgent measures in front of an arbitral tribunal, just again as a strategy decision to make the other side look bad. So they're not really even interested in the decision that they're going to get. They'll use it as a tool in front of the arbitral tribunal, knowing there's little chance they're actually going to get the measure. And then finally, some courts are going to be reluctant to grant interim measures in what they'll call foreign arbitrations, since they don't want to interfere and they don't have supervisory authority over the arbitration if it's not, again, at the place of arbitration. So we should also bear in mind that in some jurisdictions, the courts may feel that if the parties have chosen arbitration, they should go to the arbitrators for this type of relief. So again, these are strategic issues we have to look at. Now, I must say that in my own work as an arbitrator, I have seen several requests for interim measures, and the parties have preferred to do it in front of the arbitral tribunal. And fortunately, the parties have generally respected the arbitral tribunal's decisions on interim relief, much like Mark has said, because you're in front of the decision makers for your dispute and you don't want to get on the bad side of those people. So in situations where parties are actually acting in good faith and cooperating, going to the arbitral tribunal is often a much better and easier solution than involving national courts.
Well, thank you very much. Would any of the other panelists like to add anything?
I would only add, based on personal experience, that there are times where one of the parties appearing in front of the tribunal is well aware they're going to lose the arbitration from the beginning. And they may have a very different attitude about irritating an arbitrator. They may not care whether they irritate the arbitrator by ignoring an order, and I've had that experience, or they may in fact hope to irritate the arbitrator in case I make a due process mistake. And sadly, I've had that experience as well. Whether I made a due process mistake is a different issue. Of course, I think I didn't, but no court has ever said I did, but it may happen one day. But I would point out that the incentives for parties to cooperate with an arbitrator depends significantly on their perspective regarding the ultimate outcome of the arbitration.
Okay, well, thank you very much for your responses. Now we can go talk a bit about investment arbitration. As Mark had pointed out earlier, It's very different how emergency arbitration works in investment arbitration, and also if parties in investment disputes can go to national courts. This first question goes to Hugh, and it's a bit long. So, the ability to seek provisional measures from national courts in aid of arbitration, which is a common feature of commercial arbitration, is excluded from ICSID arbitration. Do you think this may result in a disadvantage for foreign investors when initiating an investment arbitration under the ICSID Convention?
So, to clarify, because I had to read this question twice since I'm a little bit daft, the ICSID arbitration doesn't exclude provisional measures. What the question is referring to is the absence of a seat under arbitration convened pursuant to the convention, which means that you would not have the traditional recourse to courts within the jurisdiction of that seat. And so the question is asking if the absence of that recourse may result in a disadvantage for foreign investors bringing a claim under ICSID as opposed to under a different system, for example, UNCITRAL. My answer is perhaps just a little bit shorter than the question itself, which is not really. And allow me to expand on this. The first reason why not really is because if you think about the context in which provisional measures are likely to arise in investment arbitration, they often, not always, but they often concern the conduct of the respondent state. These can be suits arising within the state. They can be criminal investigations and proceedings brought against parties related to the investor, if not the investor themselves, and so on. And when you think about the role of a court in introducing some type of provisional measure against that kind of conduct in, for example, the UNCITRAL context, it's not obvious that that would be particularly effective. If the courts from jurisdiction X, which happens to be the seat, were to tell jurisdiction Y that they need to cease immediately their criminal proceedings against one of the investors, whether or not jurisdiction Y is going to comply with that is, I think, at best an open question. And so the absence of a seat in that context is perhaps unlikely to make as big a difference. Now, can it potentially matter? Yes. I don't mean to sort of slam the door on that. There may be daylight for it, but it's unlikely to play the same role as it may be in the commercial context. The other point that is just perhaps worth considering in this context as well is that under ICSID, the provisional measure is recommended. It is not the same language as is used in other systems in which it can be ordered, for example. And that has prompted the spilling of some ink as to whether that can also sort of limit the ability of an ICSID tribunal to satisfy the investor's requests for provisional measures in the same way as may occur under, again, UNCITRAL. And I think that trend lines are that it does not matter here either, that the recommendation has, in effect, per several ICSID tribunals, the same impact as does an order. They have described them as effectively amounting to an order. And if you look at the compliance rates between ICSID and other bodies, they're similar in that. Where a difference does exist, and this is a little bit off-piste, but I came across it in the course of researching the answer to this question, and I thought I would flag it here, is that under the ICSID Convention, investors are much less likely to be successful in their requests for provisional measures than they are in other institutions, including the ICSID additional facility, but also with UNCITRAL. And so kind of going back to the question here, whether the absence of a seat can matter, the answer to that may be no, but it may be that ICSID in any event doesn't work to the advantage of the investor for other reasons. But others may wish to chime in as to why that is.
Thank you very much. Would any of the other panelists would like to add anything? Okay, so we can now move forward to the last question of this panel. It's also related to investment arbitration. This goes for Mark. In investment arbitration, neither the ICSID arbitration rules nor the UNCITRAL arbitration rules contain provisions for the appointment of an emergency arbitrator. Do you think this could also translate into a disadvantage for the investors initiating this type of investment arbitration?
Allow me to quote the distinguished counsel, Hugh Carlson. Not really. Emergency arbitration is, in my opinion, and I think in the opinion of most of the international arbitration community, a very valuable innovation and a fairly recent innovation. So it would be nice to have it in investor-state dispute resolution. However, investor-state dispute resolution has been around since at least the 1960s, and we've had an explosion of cases since about the year 2000 when people began to discover that NAFTA Chapter 11 arbitration could produce significant enforceable awards. And you know, we've survived quite well the last 2 decades without emergency arbitration for investor-state dispute resolution. So, is that a meaningful disadvantage for the parties? It doesn't seem to have been in the way the parties have conducted themselves, and they are truly the decision makers here, not the arbitrator. They could, if they wished, try to find a different forum for the kind of disputes that end up in investor-state dispute resolution. But the most obvious forum with jurisdiction over the parties and the ability to issue a binding and enforceable award would be the national courts of the state that is the object of the claim of wrongful conduct. And foreign investors are very skeptical that they will necessarily get a fair hearing from that national court. Whether they're right or wrong is something that people debate as a public policy matter, but the attitude of foreign investors in that regard is very clear. So, coming back to what I said at the beginning, not really.
Well, thank you very much. Yes, Professor.
I do think we have to recognize that there are differences in arbitration proceedings involving states, and for a state to assemble its legal counsel, et cetera. And so this idea of emergency arbitrators in cases involving states, it has to be put in that context where you can't have these urgent decisions before the state's even been able to put together its team to represent itself. And I think if we look even at the ICC rules, which will apply sometimes in investment cases, there's a specific exclusion where it says that the emergency arbitrator provisions will not apply to cases involving investment treaty issues. So that's a recognition, I think, of the important role of the states.
You are clearly correct there, Anne-Marie. Arbitrators in the investor-state dispute resolution arena are extremely reluctant to issue performance orders compelling a state party to do something through its regulatory or administrative arms. And indeed, if you look at the ICSID Convention draws a distinction here. Monetary awards, pecuniary obligations of arbitration awards are stated in the ICSID Convention to be binding and enforceable like any final court judgment in the courts of all member states of ICSID. But the ICSID Convention does not make the same requirement for decisions of an arbitral tribunal that are not pecuniary, that are not monetary. There's a huge skepticism that arbitrators are in a position to issue awards or decisions against states and compel states to engage in performance they would not otherwise wish to do. Money is different.
Well, thank you very much. I think that this has been a brilliant discussion. I think that all of your responses have been very enlightening, especially for those who are not as familiar with the topic. And you have given us very powerful tools and insights to continue on our professional growth. So thank you very much for being here. Thank you. So now we can have questions from the audience for a couple of minutes.
Well, if you're asking whether an emergency arbitrator can play a role in the context of an investment treaty claim, the answer is no, for the reason that you do not see the authority to create an emergency arbitrator under any of the relevant investment treaties, and certainly not under UNCITRAL. If you're asking whether the particular asset in question might be covered by a commercial contract, and therefore there might be commercial arbitration, international commercial arbitration available, then you fundamentally come down to a question where the asset is located, and whether an emergency arbitrator has the practical capacity to have an impact on who's going to control that asset and who's going to control the Russian Federation. Most commercial arbitrators sitting outside Russia with respect to an asset that's located inside Russia, for example, one of those 500 or so aircraft that are on lease, is going to be pretty skeptical that they have the ability to have a practical impact. So I think it would be the very rare circumstance where an emergency arbitrator could play a practical role in that, and consequently a very rare circumstance where a party who believes they've been injured by conduct of the Russian Federation would seek assistance of an emergency arbitrator, even in a context of a commercial contract.
Okay. Well, thank you very much. Does anyone else have any questions? Yes, Tulsi?
So one of the main modifications of UNCITRAL in 2006 was to add these ex parte provisions, but they have to be adopted by the different jurisdictions. And there are relatively few jurisdictions, as far as I know, that have adopted those ex parte provisions. And that comes back to the idea that arbitration is based on consent. And so is it normal that you're going to allow one side to have contact with an arbitral tribunal without the other side being present? Those ex parte provisions were very hotly contested in front of UNCITRAL when they were being discussed. So again, in front of a national court, it's very different because of the role the judge plays versus the arbitrator and the basis of that person's power. And I don't think that's what your direct question was, though, was. Could you repeat the exact question, Tulsi?
Basically just that, I think, Professor, you answered it. Basically that it sort of goes back to the main consent of the parties that you need. I was just asking why is it that, you can't usually get ex parte interim relief as easily as, say, in the national court?
Mm-hmm. But so the final answer would be it will depend on the jurisdiction, because some jurisdictions have adopted ex parte relief, but subject to very strong limits as far as when the other side needs to be put on notice, and those preliminary orders, is what they're called, are not enforceable like other types of interim measures.
It'll also, and this is implicit in your response, potentially be hardwired into the applicable arbitral rules, and that'll be worth consulting. I think under most systems, it would be impermissible, but I do understand there to be the rare exception. I think the Swiss rules provide some daylight for ex parte communications and actions, but most of the time, I don't think it will be available.
Thank you. And we have time for one more question. Bhavana?
Thank you for the time. I think Professor Whitesell briefly touched upon this, but I'm curious to know about why a party may choose to pursue emergency arbitration over going to a national court for interim relief, particularly when there may be two layers of proceedings involved. And especially from your practical experience, I want to know on the matters that you've worked on, has
Well, again, for emergency awards, the situation isn't completely settled. We do know there are jurisdictions. The U.S. has had decisions that have said emergency arbitrator awards are enforceable. We know there are jurisdictions like Hong Kong that the statute says these awards will be enforceable. We know other jurisdictions where they have been enforced, but the situation is not completely certain in all parts of the world. We know India, right, has had the Amazon case where they... That's right. So India has shown it's a pro-arbitration jurisdiction. So there, again, but it really does depend on the jurisdiction for the moment. It's still, if we look at the history of arbitration, a relatively new phenomenon. But as far as other parts of your question, I'm going to turn it over to my co-panelists. Anything you want to add?
Mark has his mask off, so he's gearing up.
I will always speak to fill the space available. Speed is a very important issue here. If an emergency arbitrator issues a decision, it is not binding on the subsequent full tribunal. It can be reconsidered in part or in its entirety by the tribunal that's impaneled for the purpose of dealing with the dispute in its entirety. A party might appropriately say, it's a lot faster for me to allow the arbitral institution to impanel the full tribunal, a process that's going on while the emergency arbitration is proceeding, and then seek to persuade the full panel to dispense with the decision of the emergency arbitrator, particularly if it's just preserving the status quo and the full tribunal considers that there is neither a need to preserve the full status quo, or perhaps no longer a need to preserve the full status quo. It is often the case, if there are no challenges to nominated arbitrators for the full panel, that the full panel can be up and running very quickly, more quickly than going to a national court. And that may mean that the party who is the object of the emergency decision considers they have a faster opportunity to resolve it before the full tribunal rather than seeking to go into national court. And it may not be worth their while to disagree with the emergency award while they're waiting for the full tribunal to be impaneled.
And in keeping with what Mark has said, if you look at the LCIA as another example, there is this possibility of rapidly constituting the tribunal. Rather than appointing an emergency arbitrator, have a faster constitution of the real tribunal that's going to hear the case to deal with the fact that there may be urgent measures. And that has a lot, I think, to say for it, because, again, you get the real decision makers who are going to be deciding the case.
I think part of your question, please correct me, was sort of the frequency with which these are challenged. Is that right? I'm drawing from a very limited sample, but we haven't had difficulty in my experience. But here it's worth underscoring a point that I think Anne-Marie has made, which is that not only is this unsettled, but it is very much sort of part of the wild, wild west of international arbitration. Emergency arbitration is still sort of growing into its own. I think 2006 is kind of when we started to see it take off, and even then it took some time before it was introduced in the arbitration rules of many of the institutions with which you will be familiar. The ICC had a report around 2019 in which I think that they had seen 40 emergency arbitrations by that point in time. And so it's difficult, just to kind of come back to your question, to extrapolate from that sort of broader trends in their enforceability and the degree to which they're complied. I think that this will be one of those areas in which you as practitioners will probably see more action, more development than we have in the decade behind us.
And I think an important element in what Hugh has just said is, what do the emergency arbitrators grant? Because when we talk about enforcement, it's as if they're granting something. And if you look at least I know those ICC decisions, many of them did not grant the interim measure
Yeah,
that was
it's
requested.
an excellent point.
So then there's nothing to seek enforcement of.
Okay, well, thank you very much. Thank you, Mark, Hugh, and Professor Whitesell. This has been a great discussion. We would also like to thank our sponsors and supporting organizations for making this event possible. We will have a networking break and coffee right outside, so see you there.